In this video, I'm going to give you my framework for how to prove domestic violence in an order of protection hearing or custody case. Guys, my name is Kyle Kaufman. I'm a family law attorney in Wisconsin, hkklawoffices.com. Now, I've been practicing for 19 years, and in that time, I've learned that if you do not prepare properly for domestic violence cases and seeking an order of protection in a hearing or a custody case, you're going to lose your case. Now, everyone, this video does discuss sensitive topics, things like assault, sexual assault, and abuse. And that might be distressing for some of our viewers. So please take care of yourself while watching this video. If you are a victim of domestic violence yourself, please seek help for that. And if you're an abuser and you're watching this video, I also encourage you to seek help. There's resources for both sides in this. And the goal overall is to break the cycle and make this a more peaceful world. Thank you. These matters are emotionally complicated. They involve specific facts. Now, it is your job to make sure that the court has factual information that is necessary to decide the case in your favor. Before I share my framework with you, I want to tell you why I'm doing this. I had a client that came to me, and frankly, she had worked with an attorney who had not helped her. This woman was now being forced to raise a child with her abuser. I questioned, how could this happen? The client was questioning the same thing. And what we discovered is that the attorney who represented her had made mistakes along the way, and as a result, did not serve this client well. Now, my framework was developed based on my sympathy for that client, that I was now tasked with helping in further legal matters involving custody and placement of her child with her abuser. I was astonished that our court system forces victims of domestic violence and abuse, sometimes the worst type of abuse, and I'm talking about things like sexual assault and rape, to now turn around and have to parent and co-parent with a person who abused them. This dynamic is completely unfair. The whole point of domestic violence, there's no point of it, but what it does do is it takes an advantage of somebody. It's an unequal playing field. The abuser gets their way by abusing. So when you are raising a child with your abuser, it's natural then for the victim to want to consent to what the abuser says, or they face the risk of harm or bodily endangerment, death, or sexual assault. So as an attorney, the first thing that I do is I listen to the person who came to see me seeking help. And if you're an attorney and you're watching this video, the most important step in this process is this step. It is step number one. You have to allow the person to talk and you have to listen. Take notes while the person is talking. Be sympathetic to their story. Allow them to express themselves. Remember, you are a stranger. You have to be open-minded and create an environment and an atmosphere where this person trusts you and will speak to you and share some of the most intimate and embarrassing details of their life. If you're self-represented and you're watching this video, then I encourage you, listen to yourself. If you are the victim, give yourself the peace of mind knowing that what you are telling yourself are the facts. Respect yourself and don't dismiss them. And if you're the attorney, it's the same thing. Don't dismiss the facts. Just listen. Accept it for what it is. And if you're up for the challenge, then you're willing to listen and share the stories. And you have to do that in front of others in a courtroom, to a judge, to other attorneys, to the abuser. And you have to take those facts and go ahead with your case in order to protect or address these matters in a custody case. Over the course of time, I've developed a series of forms that I use to ask my clients to complete. The most important form, in my opinion, is called the Safety-Focused Parenting Plan. And in that form, I ask very specific questions about domestic abuse. I ask my clients to respond by indicating who, what, where, when, why, and how. Now, I know this seems relatively simple, but in fact, most people have never been asked to complete a form that asks questions about hitting, kicking, punching, shoving, breaking, sexual assault, hurting, and more. And it could even be threats of these things. I dive into related issues that often come up with domestic violence, things like drugs, alcohol, and mental health issues. Now, I use the forms as a tool. It helps my clients develop their stories. It's not uncommon for a victim to want to forget about what happened to them, block it out, right? They suppress their memories, and as a result, sometimes their initial stories lack detail or supporting information. But by asking my clients to complete the forms, as hard as it might be, and look, I do not want it to harm my clients to make them think about these hard things. I do it to help them. But by completing the forms, it draws out the stories and gives me more information. So if you're self-represented and you're not an attorney who's watching this, what you would want to do is write down what happened, and you want to write down specifically, to the best of your memory, who, what, where, Why, when, and how. Document it. And what I have discovered with my clients is that what they think is normal and part of their everyday life is not always normal to me or the court system. And I discovered that most people see things that's an everyday thing in their life is in fact criminal and harmful, and that needs to come out. The next part of my framework is to read the forms that my clients completed. Now, many times the forms are incomplete. By reviewing the statements that my clients completed and reviewing the statements with my clients, it helps them to remember the incident. It jogs their memory. It helps them prepare for telling the stories in front of others, people like a judge or an attorney or a child advocate. Now, if you're self-represented and after you've completed the forms or written down your stories, if you read them out loud, you'll find yourself asking questions and noticing holes in your story. So it's important to be detailed. In my opinion, courts find that the more credible party is the person who can tell the story with the greater detail. For example, if I said the event happened sometime within the last 10 years versus the event happened on April 3rd, 2023 at 5 p.m. outside my mother's home, the second statement is more detailed and it's more trustworthy. In reviewing the forms with my clients, I remind them that the task here is to prove the allegations because unfortunately in our system, people tend not to believe them. I operate under the condition that they just simply won't be believed. And then it's my job as their attorney to over-deliver and to provide as much factual information to the court to convince the court that these events are in fact true, unfortunately and regrettably, and to get the protection my clients need, that they deserve. I tell my clients that that's my job, is to help them tell their story. And if the court simply does not believe them or grant them the request that they're looking for, that they're seeking, then that is on the court and it's not on the client. Because the client did everything they could do to tell their factual story to protect themselves and their children. The fourth step in my framework is to consider what evidence you have to prove your case. Now, another way to ask this is, what tools do I have that are available to me based on the stories that I know that I can use to help convince the court that this is true and to grant the relief my client seeks? Now, in my opinion, this generally falls into two categories. It's evidence that could come in from a witness or evidence that's going to come in the form of a paper document. Witnesses can include your client, the opposing party, and the other people who observed acts of domestic violence or abuse or observed injuries or events that help substantiate the story. Paper documents, if I called it that, include things like police reports and medical records and pictures, videos, text messages, and emails. So in the third step, earlier, when I'm talking about reviewing my client's statements, earlier in my framework, what I'm listening to my clients, when I'm listening to them, I'm always making mental notes to remind myself of the who's and the how that I can prove this. So in this fourth step, it's entirely important that you make a list and simply list out what you would need at trial before a court in order to prove your case. Your mind will just naturally go to work. You'll start thinking of all the people that need to be there to tell the story. Your mind will go to the work that needs to be done. It'll think about the evidence that you need to tell your story. Now, you then have a plan. And you go and you get that information. Other than interviewing your client, you want to interview other witnesses and ask them questions as well about what they saw and what they heard, what they observed. You want to go and get police reports if the police were involved. You'd want to obtain medical records if the client obtained medical services or care following any event. The other things you want to consider are pictures. Right? If you have pictures that demonstrate domestic abuse, damage to property, you want to secure that and get that information. If you have recordings or videos between you and the abuser, and specifically where there's domestic violence occurring or threats of it in the videos or the recordings, you want that. Text messages, really important these days, or emails. You would want those messages and emails that are sent by the opposing party. Oftentimes they end up apologizing in text messages or emails, and you want that information. The next thing I want you to consider in my framework is, what can I get from the opposing party, the abuser? So far we've talked about really what you have or what you have access to. But sometimes in an order for protection hearing, you don't have a lot of time to do what we call discovery as lawyers. You generally have time to do discovery in custody cases, but when you're seeking an order for protection, that's usually happening in a very short order of time. Discovery is a tool within our statutes here in Wisconsin. It allows us to obtain information from the opposing party prior to the hearing. And that can be obtained through interrogatories, a request for production of documents, a deposition, or request for admissions. Now, some of my favorite discovery tools to use prior to a hearing include interrogatories, the request for production of documents, and requests for admissions. Now, requests for admissions really are a very nice tool. If you're not familiar with them, consult with your attorney because they can be complicated. But essentially, you want to create a list of questions and ask the opposing party to admit or deny the fact in your question. You can then submit the request for admissions to the opposing party. And in the state of Wisconsin, the other side has 30 days to reply with an admission or a denial. Now, this may give you some relief as you don't have to wait to go to court to find out how they'll answer the question. Will they admit or will they deny? And so then you know in advance. And even if they deny it, now you know that they're lying because you may have information available to you that you can use to impeach the person at trial. That is showing the court that they're not being truthful. So if the person has admitted to a bad fact that amounts to domestic violence or abuse in the admissions, those admissions are probably going to be enough to win your case right there. The other form of discovery I like to use is interrogatories. Interrogatories are a series of open-ended questions rather than asking somebody to admit or deny. So you ask these open-ended questions to the opposing party, and that person has 30 days to respond. So rather than asking a simple do you admit or deny, you would ask them to tell the story. You would ask them for their opinion. You would ask them to further detail the event so you know what they're going to say when they come to the hearing. What are their potential defenses? What is a request for production of documents? It's another tool I like to use. Well, that's information that the abuser might hold or possess. So what information do they have? And you can ask them to produce that information. In a case involving domestic abuse or violence, you may want the person to produce the text messages or emails or pictures or photos that exist or you believe they exist and are relevant to the domestic abuse proceedings. As I stated with orders of protection in Wisconsin, we call those restraining order hearings or injunction hearings in Wisconsin. You oftentimes, though, in those cases do not have these 30 days in advance to do formal discovery with interrogatories, a request for admissions, or a request for production of documents. So you might be able to move quickly by setting up a deposition, another way to do discovery. Now, a deposition, you can depose the opposing party, the abuser, prior to going to the hearing on domestic violence. Now, a deposition, it's basically questioning a person under oath outside of a courtroom. You would then want to obtain the transcript from the court reporter who comes to the deposition. After the deposition is complete, you get that transcript, and you would use that transcript then to confront the witness at the actual hearing in front of the judge. Discovery is tricky. Now, I really encourage you to talk to an attorney so you understand the process and know what you're doing. The next step in my framework is to prepare your exhibits for trial. You need to know the rules of where your case is. Now, I'm in Wisconsin. I'm familiar with the rules here. Each county sometimes has different rules as well as to how we handle evidence. So check for your jurisdiction and talk to a lawyer. You may need to file your exhibits in advance, or you might be allowed to bring them to the court hearing. Consult with an attorney. You got to know those rules. You want to make sure that you have enough copies for everyone. So if you intend to use text messages in your case, you cannot simply pull out your phone and say, hey, judge, I have a bunch of text messages I want you to read. It just doesn't work that way. You are not able to bring your laptop to the court, pull up a bunch of emails, turn it around, and expect the court to sift through your email inbox and read your emails. Exhibits are important, and if you prepare them professionally and either file them in advance or have them ready at your hearing, depending on the rules in your jurisdiction, it will make a difference. And going back to the discovery that we talked about earlier, the reason you seek the information from the opposing party is to know what they are bringing to court. And if they don't produce it to you in the discovery in advance, that's a problem for them when they later try to bring it up in trial, right? So you want to make sure that you're doing the right things first. Have your police reports and medical records, pictures, videos, text messages, and emails. Get them ready. Make sure that your videos and recordings are able to be played in the courtroom. How are you actually going to play it? Do you know the rules and the technology capabilities of the courtroom? Will the court even allow for it? You have to figure that out ahead of time. Now, not every court hearing allows for itself to be a long hearing, right? So you need to know how much time you have for your hearing. A hearing is typically 30 minutes to an hour. Now, I do not like to rush my cases because I don't like to rush to justice. I want the judge to know the facts. And if there are facts and evidence that support abuse, then I want to take the time to make sure that the court has all the information to make the right decision. So as I listen to my client and I read their forms and I ask for more information and discover all of their evidence, I realize this is going to be quite a bit of evidence and I'm going to need a significant amount of time in a courtroom. Then I notify the court of that in advance. Now, some types of hearings cannot be moved or adjourned, and they must be done in a shorter period of time. So in that event, you try to highlight the acts of domestic violence and abuse that are most relevant. Hopefully there's not a lot at the end of the day, right? We really don't want that. But if it exists, highlight the ones that are most relevant. Some people, unfortunately, are abused quite a bit, and there's lots of stories to tell, while others may have 1 or 2 stories to tell. So overall, what you want to do is find the ones that are most likely to get the outcome that you want, which is an order for protection, or in a custody case, that you have some orders that protect you and the children. The next step in my framework is to organize your witnesses and make sure that they make it to the courtroom. As you can imagine, lots of people like to talk and share stories, but once you tell them that you want them to actually come before a judge, they get reluctant. And these witnesses may say things like, oh, well, I don't want to be involved. And, the fact of the matter is they are involved. They're a witness. They just are. So you're not asking them to come there to give their opinion on anything. You're just asking them to come and funnel the factual information to the court, the things that they know, right? The things that they observed, what they heard, what they saw. And it's your job to get the witnesses there. So that might require you to issue subpoenas. That requires them to come to court, even reluctantly, right? Like they don't want to come, now they have to come. You certainly will want to work with an attorney on this if you need to do subpoenas, because the average person is not going to know how to do that on their own. Who are some potential witnesses in a case like this? Your client, or if you're the victim, of course, is a witness, right? You would tell the facts yourself, or your client would. They have to relay the story of what happened. The opposing party is a witness because they know what happens. And you want to get certain information from the opposing party, the abuser. I often like to call, as one of my first witnesses, the abuser. I like to do that to set the table. It's not uncommon for abusers to lie. The abusers have their own version of the events, and what this does, it allows your client, when the abuser is testifying first, to listen to what the abuser is saying. And it allows them an opportunity to prepare as to how they might testify in response to what this person is saying, typically lying about. And it helps to calm the nerves of your own client and their emotions. It makes them feel better. And the other witnesses then that I would consider, other than the opposing party and your client, would include people like police officers. It could be an emergency response person or medical care provider. It could be a family member or a friend, or just any other witness. Now, if your witnesses need accommodations for work or travel reasons, it's not uncommon for courts to approve of witnesses appearing remotely by Zoom video conference or telephone. But if you want to do that, you need to ask in advance. So keep in mind, many of these witnesses, they might be working throughout the day, and their employer will be upset if they're leaving work to go to testify in court. So you want to give your witnesses as much advance notice as possible. If you have an unwilling witness, you certainly need to consider those subpoenas to get that person there. I recommend only involving witnesses, though, that have relevant information. Those witnesses are people that see things and hear things that amount to acts of abuse or domestic violence, not what they believe or what they heard from you, okay? Now, you've made it to the hearing. You've got yourself there. It's your day of court, and you followed the framework here that I've laid out. And what you have to do next is make sure that you're presenting a combination of the testimony and exhibits to prove your case. And when I ask my clients to testify at these types of emotional hearings, I ask them, it's very difficult, but I ask them to suspend belief for a moment and pretend while they're testifying that they're basically just a reporter. And I ask them to testify, and I say this to them, I said, pretend you're up in the air and you're looking down at yourself, and you're basically telling the court what happened, and you're trying not to be emotional about it, because the emotions can oftentimes cause distraction and they get away from just telling the detail. I ask them to think about what a police officer does when they come and testify. And an officer who comes to a scene of a crime, they observe things, and then they make a report, and when the officer testifies in court, the officer comes in and says, yes, on this day I went there, and this is what I saw. So what I try to do with my clients is to try to stick to the facts, remind them that that's what we're there for, is to give the factual information to the judge so the judge can make the right decisions. Through the testimony, I'll ask, of course, did it hurt? Are you scared? And things of that nature. But ultimately, I want to stick to the facts of the case with every other witness. I have a plan for each witness. What is 1, 2, or 3 things that I want to get out of each witness that only that witness knows about or can answer? There's no reason to bring in multiple witnesses to say the same thing over and over, other than if your client has said it and then you have another witness to come in to reinforce that. That is very helpful. But I really try to focus on just the best and juiciest details and have that witness testify to that. Now, as to the exhibits, I want my exhibits, right, to help support the testimony, the stories that the witnesses are telling. So I challenge my witnesses with that information. If they're adverse witnesses, you want to use the documentation to impeach them to show that they're lying. So, for example, if you have a text message from an abuser that says something so awful such as, "If I see you again, I'm going to kill you," and you have already asked the abuser previously if an abuser ever made a statement such as that and it was denied, as no, I never said that. Well, now you have your text messages and you can use that to challenge the abuser, and immediately that person is called out, right? You want the abuser to agree with you on as many things as possible, set them up that way. You basically want the abuser to be backed into a corner. And faced with so much testimony and evidence, they simply cannot deny what happened. They've painted themselves essentially into a corner. They can't get out. So if they are denying it and it's so obvious to the court that they're lying, it just comes out, it's so clear. So organize your testimony and exhibits accordingly. That's part of the framework here. You just have to plan, and plan. Overall, what my framework does and is designed to do is to funnel factual information to the fact finder, who's the judge. I want to remind you that a judge's decision is only as good as the facts it relies on. So it is your job to tell the stories and to give the facts to the judge. Facts can come in through witnesses and documentary evidence. That's the paper documents, and you have to give it to the court. If you leave those facts out, then the decision will be made without the facts, and you won't get another chance to present your evidence. This is the time to do it. So funnel the factual information to the court. Now, that's my framework, guys. It's not complicated, but it does require work. And remember, you need to listen. You need to write it down. You need to read it. You need to practice saying it, gather the evidence, and the tools that you need to prove your case. Consider using discovery to obtain information from the opposing party. Prepare your exhibits, organize your witnesses, and make sure to get them to the hearing. And at your hearing, present your witnesses' testimony and exhibits in a manner that's organized and it makes sense. And you want to funnel that factual information to the judge to get the decision that you want. Earlier, I talked to you about that client that came to me, and I want to tell you that we got a positive result for her. And we followed this framework, and we said, no matter what, we're going to court, we're going to tell our story, we're going to present our factual documentation, and we're going to leave it up to the fact finder to decide what to do. And we got a good result. And I'm so proud that we did that together and that client had the courage to do it. You need to work with an attorney who believes in you, and you need to work together as a team. Now, domestic violence is just a terrible thing, and it really is a plague in our society. I believe strongly in breaking the cycle. So we're here to help. Many other attorneys are out here helping as well. Consult with an attorney if you find yourself in a situation like this, and consider an order of protection, a temporary restraining order, or an injunction. And certainly, if there's abuse, bring it to the attention of your judge in your custody case. Call the police. I'm Kyle Kaufman, attorney at HKK Law Offices. You can reach out to us for further information if you have questions or you wish to consult with us. Remember to subscribe to our channel, like, and leave some comments. Thank you. I'll see you next time.